Law enforcement in the United States is one of three major components of criminal justice system of the United States, along with courts and corrections. Although each component operates semi-independently, the three collectively form a chain leading from investigation of suspected criminal activity to administration of criminal punishment. Also, courts are vested with the power to make legal determinations regarding the conduct of the other two components. Law enforcement operates primarily through governmental police agencies. The law enforcement purposes of these agencies are the investigation of suspected criminal activity, referral of the results of investigations to the courts, and the temporary detention of suspected criminals pending judicial action. Law enforcement agencies, to varying degrees at different levels of government and in different agencies, are also commonly charged with the responsibilities of deterring criminal activity and preventing the successful commission of crimes in progress. Other duties may include the service and enforcement of warrants, writs, and other orders of the courts. Law enforcement agencies are also involved in providing first response to emergencies and other threats to public safety, the protection of certain public facilities and infrastructure, the maintenance of public order, the protection of public officials, and the operation of some correctional facilities. Types of police. Policing in the United States is conducted by numerous types of agencies at many different levels. Every state has their own nomenclature for agencies, and the powers, responsibilities and funding varies from state to state. Federal main article, Federal law enforcement in the United States. See also, Law Enforcement Agency section. Federal responsibilities. At the federal level, there exist both federal police, who possess full federal authority as given to them under United States Code, and federal law enforcement agencies, who are authorized to enforce various laws at the federal level. Both police and law enforcement agencies operate at the highest level and are endowed with police roles. Each may maintain a small component of the other. The agencies have nationwide jurisdiction for enforcement of federal law. All federal agencies are limited by the U.S. Code to investigating only matters that are explicitly within the power of the federal government. However, federal investigative powers have become very broad in practice, especially since the passage of the USA Patriot Act. The Department of Justice is responsible for most law enforcement duties at the federal level. It includes the Federal Bureau of Investigation, the Drug Enforcement Administration, the Bureau of Alcohol, Tobacco, Firearms, and Explosives, the United States Marshals Service, the Federal Bureau of Prisons, and others. The Department of Homeland Security is another branch with numerous federal law enforcement agencies reporting to it. U.S. Customs and Border Protection, U.S. Immigration and Customs Enforcement, Federal Air Marshal Service, United States Secret Service, United States Coast Guard, Homeland Security Investigations, and the Transportation Security Administration are some of the agencies that report to DHS. It should be noted that the United States Coast Guard is assigned to the United States Department of Defense in the event of war, at a crime or disaster scene affecting large numbers of people, multiple jurisdictions, or broad geographic areas. Many police agencies may be involved by mutual aid agreements. For example, the United States Federal Protective Service responded to the Hurricane Katrina natural disaster. Command in such situations remains a complex and flexible issue. In accordance with the federal, as opposed to unitary or confederal, structure of the United States government, the national government is not authorized to execute general police powers by the Constitution of the United States of America. Each of the United States' 50 federated states retain their own police, military and domestic law-making powers. The U.S. Constitution gives the federal government the power to deal with foreign affairs and interstate affairs. For policing, this means that if a non-federal crime is committed in a U.S. state and the fugitive does not flee the state, the federal government has no jurisdiction. However, once the fugitive crosses a state line, they violate the federal law of interstate flight and is subject to federal jurisdiction, at which time federal law enforcement agencies may become involved. Most states operate statewide government agencies that provide law enforcement duties, including investigations and state patrols. They may be called state police or highway patrol, and are normally part of the State Department of Public Safety. In addition, the Attorney General's office of each state has its own State Bureau of Investigation. In Texas, the Texas Ranger Division fulfilled this role, though they have the history in the period before Texas became a state. Various departments of state governments may have their own enforcement divisions, such as Capitol Police, Campus Police, state hospitals, departments of correction, water police, environmental game wardens, or conservation officers. In Colorado, for instance, the Department of Revenue has its own investigative branch, as do many of the state-funded universities. County, also known as parishes and boroughs. County law enforcement is provided by sheriff's departments or offices and county police. County police tend to exist only in metropolitan counties and have county-wide jurisdiction. In some areas, there is a sheriff's department which only handles minor issues such as service of papers and security for the local courthouse. In other areas, there are no county police and the local sheriff is the exclusive law enforcement agency and acts as both sheriff and county police, which is more common than there being a separate county police force. County police tend to fall into three broad categories. Full service, provide the full spectrum of police services to the entire county, irrespective of local communities, and may provide contractual security police services to special districts within the county. Limited service, provide services to unincorporated areas of the county, and usually provide contractual security police services to special districts within the county. Restricted service, provide security police to county-owned and operated facilities and parks. Some may also perform some road patrol duties on county-built and maintained roads, and provide support to municipal police departments in the county. Some northeastern states maintain county detectives in their county attorney's offices. For example, the Commonwealth of Virginia does not have overlapping county and city jurisdictions, whereas in the other 49 states most municipalities fall within a county. In Virginia, governmental power flows down from the state directly to either a county or an independent city. Thus, policing in Virginia is somewhat simplified where a county sheriff's office department or county police department does not overlap with an independent city police department. Unincorporated townships remain part of the parent county, but may have town police departments to augment their county law enforcement. Town police departments are often small, and may deploy a combination of paid and non-paid, full and part-time law enforcement officers, including auxiliary officers who typically serve as part-time, unpaid volunteers. If present, independent city sheriff's officers usually follow the restrictive model shown below for sheriff's departments, with limited law enforcement authority including warrant service, jail bailiff, etc. Mutual assistance compacts may exist where neighboring law enforcement agencies will assist each other. However, In addition to state law enforcement resources, sheriff's offices full service, the most common type, provide all traditional law enforcement functions, including county-wide patrol and investigations irrespective of municipal boundaries. Limited service, along with the above, perform some type of traditional law enforcement functions such as investigations and patrol. This may be limited to security police duties on county properties to the performance of these duties in unincorporated areas of the county, and some incorporated areas by contract. Restricted service provide basic court-related services such as keeping the county jail, transporting prisoners, providing courthouse security and other duties with regard to service of process and summonses that are issued by county and state courts. The sheriff also often conducts auction sales of real property in foreclosure in many jurisdictions, and is often also empowered to conduct seizures of chattel property to satisfy a judgment. In other jurisdictions, these civil process duties are performed by other offices, such as a marshal or constable. In Texas, the sheriff's office is normally the agency responsible for handling mental health calls. If the situation is dangerous, a sheriff's deputy has the power to take a person to a hospital on a mental health commitment immediately. However, if the situation is not actively dangerous, a warrant must be sought. With the rise in mental health units across the state, the Texas CIT Association was formed. Municipal police departments of the United States. For a list, municipal police range from one-officer agencies to the 50,000 persons strong of the New York City Police Department. Most municipal agencies take the form police department. Many individual cities and towns will have their own police department, with larger communities typically having larger departments with greater budgets, resources, and responsibilities. Metropolitan departments, such as the Las Vegas Metropolitan Police Department, have jurisdiction covering multiple communities and municipalities, often over a wide area, typically coterminous with one or more cities or counties. Metropolitan departments have usually been formed by a merger between local agencies, typically several local police departments and often the local sheriff's department or office, in efforts to provide greater efficiency by centralizing command and resources and to resolve jurisdictional problems, often in communities experiencing rapid population growth and urban sprawl, or in neighboring communities too small to afford individual police departments. Some county sheriff's departments, such as the Los Angeles County Sheriff's Department, are contracted to provide full police services to local cities within their counties. Other see specialist police departments of the United States. For a list, there are other types of specialist police departments with varying jurisdictions. Most of these serve special-purpose districts and are known as special district police. In some states, they serve as little more than security police, but in states such as California, special district forces are composed of fully sworn peace officers with statewide authority. These agencies can be transit police, school district police, campus police, airport police, railroad police, park police, or police departments responsible for protecting government property, such as the Los Angeles General Services Police. Some agencies, such as the Port Authority of New York and New Jersey Police Department, have multi-state powers. There are also some private agencies, such as the Co-op City Department of Public Safety, Puerto Rico Police. The Puerto Rico Police traces back to 1837, when Spanish Governor Francisco Javier de Moreda y Prieto created La Guardia Civil de Puerto Rico to protect the lives and property of Puerto Ricans who at the time were Spanish subjects, and provide police services to the entire island. Even though many municipalities maintain their own police force, the United States and invaded and took possession of Puerto Rico in July 1898 as a result of the Spanish-American War and has controlled the island as a U.S. territory since then. The Insular Police of Puerto Rico was created on February 21, 1899, under the command of Col. Frank Thacker, with an authorized strength of 313 sworn officers. As of 2009, the PRPD had over 17,292 officers. Police functions. Textbooks and scholars have identified three primary police agency functions. The following is cited from the American System of Criminal Justice, by George F. Cole and Christopher E. Smith, 2004, 10th edition, Wadsworth Thompson. Learning, or order maintenance. This is the broad mandate to keep the peace or otherwise prevent behaviors which might disturb others. This can deal with things ranging from a barking dog to a fist fight. By way of description, Cole and Smith note that police are usually called on to handle these situations with discretion, rather than deal with them as strict violations of law, though of course their authority to deal with these situations are based in violations of law. Law enforcement. Those powers are typically used only in cases where the law has been violated and a suspect must be identified and apprehended. Most obvious instances include robbery, murder, or burglary. This is the popular notion of the main police function, but the frequency of such activity is dependent on geography and season. Service. Services may include rendering first aid, providing tourist information, guiding the disoriented, or acting as educators. Cole and Smith cited one study which showed 80% of all calls for police assistance did not involve crimes. But this may not be the case in all parts of the country, because police agencies are traditionally available year-round, 24 hours a day. Citizens call upon police departments not only in times of trouble, but also when just inconvenienced. As a result, police services may include roadside auto assistance, providing referrals to other agencies, finding lost pets or property, or checking locks on vacationers' homes. History. Early policing in American history was based on the ancient English common law system, which relied heavily on citizen volunteers, watch groups, and a conscription system known as posse comitatus, similar to the militia system, which continued until the mid-19th century. Police reform. There have been many initiatives to reform policing, notably since the 1960s, under President Lyndon Johnson, and several more recent efforts. Police departments across the country continue to be scandalized by instances of corruption and brutality. Reforms based on community dialogue, legal requirements and updating of police training is growing. Militarization of police. The militarization of both rural and urban law enforcement has been attributed to the United States' involvement in wars during the 20th century, although some attribute the militarization to the more recent campaigns on drugs and terror. Historian Charles Beard argues that cultural change during the Great Depression encouraged the militarization of law enforcement, whereas Harwood argues that the creation of SWAT teams and tactical units within law enforcement during the 1960s began such trend. Such drastic changes are also attributed to offenders using high-powered weaponry and personal body armor in an attempt to defeat law enforcement, when unaware they are engaged by the police. In recent years, the use of military equipment and tactics for community policing and for public order policing has become more widespread under the 1033 program. Lawmakers have begun to discuss the topic. Styles of policing. Given the broad mandates of police work, and yet having limited resources, police administrators must develop policies to prioritize and focus their activities. Some of the more controversial policies restrict, or even forbid, high-speed vehicular pursuits. Researchers Falcone, Wells, and Weishutz describe a historical separation of police models between small towns and larger cities. The distinction has also been defined between rural and urban policing models, which tended to function differently with separate hierarchical systems supporting each. Three styles of policing develop from a jurisdiction's socio-economic characteristics, government organization, and choice of police administrators. According to a study by James Q. Wilson, there were three distinct types of policing developed in his study of 8 communities. Each style emphasized different police functions, and were linked to specific characteristics of the community the department served. Watchman emphasizes maintaining order, usually found in communities with a declining industrial base, and a blue-collar, mixed ethnic racial population. This form of policing is implicitly less proactive than other styles, and certain offenses may be overlooked on a variety of social, legal, and cultural grounds, as long as the public order is maintained. Smith and Cole comment the broad discretion exercised in this style of policing can result in charges of discrimination. When it appears police treatment of different groups results in the perception that some groups get better treatment than others. Legalistic emphasizes law enforcement and professionalism. This is usually found in reform-minded cities with mixed socio-economic composition. Officers are expected to generate a large number of arrests and citations, and act as if there were a single community standard for conduct, rather than different standards for different groups. However, the fact that certain groups are more likely to have law enforcement contact means this strict enforcement of laws may seem overly harsh on certain groups. Service emphasizes the service functions of police work, usually found in suburban, middle-class communities where residents demand individual treatment. Police in homogeneous communities can view their work as protecting the citizens against outsiders, with frequent but often informal interventions against community members. The uniform makeup of the community means crimes are usually more obvious, and therefore less frequent, leaving police free to deal with service functions and traffic control. Wilson's study applies to police behavior for the entire department over time. At any given time, police officers may be acting in a watchman, service, or legalistic function by nature of what they're doing at the time, or temperament, or mood. Individual officers may also be inclined to one style or another, regardless of supervisor or citizen demands. Community-oriented policing is a shift in policing practices in the U.S. that moved away from standardization and towards a more preventative model where police actively partner with the community it serves. Powers of officers. General powers. Law enforcement officers are granted certain powers to enable them to carry out their duties. When there exists probable cause to believe that a person has committed a serious crime, a law enforcement officer can handcuff and arrest a person, who will be held in a police station or jail pending a judicial bail determination or an arraignment. The procedural use of strip searches and cavity searches by law enforcement has raised civil liberties concerns. The practice of taking an arrested person on a perp walk, often handcuffed, through public place at some point after the arrest, creating an opportunity for the media to take photographs and video of the event, has also raised concerns. In 2010, the FBI estimated that law enforcement agencies made $13,120,947 7 arrests. Of those persons arrested, 74.5% were male and 69.4% of all persons arrested were white, 28.0% were black, and the remaining 2.6% were of other races. A law enforcement officer may briefly detain a person upon reasonable suspicion of involvement in a crime but short of probable cause to arrest. Contrary to popular belief and Hollywood-style depictions in TV and movies, merely lawfully detaining a person in and of itself does not deprive a person of the Fourth Amendment right against unlawful searches. Federal, state, and local laws, and individual law enforcement departmental policies govern when, where, how, and upon whom a law enforcement officer may perform a pat-down, protective search, or Terry frisk, based on several U.S. Supreme Court decisions: Michigan v. Long, Maryland v. Buey, in Terry v. Ohio, the landmark decision introducing the term Terry frisk, or frisk, to the broader public. Our evaluation of the proper balance that has to be struck in this type of case leads us to conclude that there must be a narrowly drawn authority to permit a reasonable search for weapons for the protection of the police officer, where he has reason to believe that he is dealing with an armed and dangerous individual, regardless of whether he has probable cause to arrest the individual for a crime. The officer need not be absolutely certain that the individual is armed. The issue is whether a reasonably prudent man in the circumstances would be warranted in the belief that his safety and that of others was in danger. The New York City Police Department came under scrutiny in 2012 for its use of a stop-and-frisk program. Civil asset forfeiture. The Supreme Court ruled that law enforcement officers may enter a house without knocking if they have a reasonable suspicion that announcing their presence would be dangerous or allow a suspect to destroy evidence. In addition, rules on civil asset forfeiture allow law enforcement officers to seize anything which they can plausibly claim was the proceeds of a crime. The property owner need not be convicted of that crime. If officers find drugs in a house, they can take cash from the house and possibly the house itself. Commentators have said these rules provide an incentive for law enforcement officers to focus on drug-related crimes rather than rape and murder investigations. They also provide an incentive to arrest suspected drug dealers inside the houses, which can be seized, and to raid stash houses after most of the drugs have been sold, when officers can seize the cash. Deadly force. Use of deadly force is often granted to law enforcement officers when the person or persons in question are believed to be an immediate danger to people around them, or when a person poses a significant threat to a law enforcement officer, usually when the officer is at risk of serious bodily injury or death. Most law enforcement agencies establish a use of force continuum and list deadly force as a force of last resort. With this model, agencies try to control excessive use of force. Nonetheless, there are a high number of killings by law enforcement officers, including killings of people who are unarmed, raising questions about widespread and ongoing excessive use of force. Other non-fatal incidents and arrests have raised similar concerns. Misconduct. Several serious cases of police misconduct have raised questions surrounding abuse of powers by individual or groups of officers. Historical examples include the Chicago Police Department's torture of felony suspects between 1972 to 1991 by and under John Berg. Los Angeles Police Department's 1991 beating of Rodney King and late 1990s LAPD rampart scandal. New York City Police Department's 1970s fatal shootings of Clifford Glover and Randolph Evans. The 1980s chokehold of Michael Stewart. Shootings of Eleanor Bumpers and Edmund Perry. The stun gun torture of Mark Davidson. The 1990s torture of Abner Louima and shooting of Amadou Diallo, the 2000s shootings and record publicizing of Patrick Dorismond and Sean Bell. Philadelphia Police Department's torture of suspects in the 1970s to improve then-Mayor Frank Rizzo's reputation, and Torrington, Connecticut's Tracy Thurman,